Okay, we're going to talk about rights and land. Rights and land, not title, not legal ownership. This is just rights and land. I have Green Acre, you own Black Acre, we're neighbors, maybe we're not neighbors. The bottom line is I'm giving you the right to come onto my land to do something, but you have no legal title. This is just about literally giving you permission or granting you the right to do stuff. So never be looking for an answer about title when we're talking about these kind of questions. And like I always say, it's just a bunch of words that have different definitions, different ways, different titles, different names of interests that I grant you to come onto my property. Keep them separate. You'll know what the hypo looks like because they'll have to tell you. And these are actually not so bad. The first right we'll talk about is an easement. Easement. The right to come onto my land to do something. I'm granting you the right or preventing you from doing something on my property. Easement. An easement can be created a couple of different ways. In all of these kind of interests, we're basically just going to talk about what are they, how do they create, how long will they last, and how do I terminate it? Keep those separate. So there's a couple different ways you can create an easement. The first one, obviously, in writing. You and I can have an express agreement. We can write something out saying, I hereby grant you the right to come onto my land to use the path, to do something. It can be created by prescription, easement by prescription. An easement by prescription looks like adverse possession. Looks like adverse possession, meaning you come onto my land and use the land in a certain way for the statutory period of time, and once all those elements are met, you now have acquired an easement by prescription. The difference, of course, is you don't have title. It's just that you've used my property the same way for so long, etc., and filled in all those elements. Now you've acquired the right to do it, and therefore I can't stop you from doing it any longer. So easement by prescription means it looks like adverse possession. You've been doing it the same way for the statutory period of time, but now you've only got the right to do it, no title. The elements are the same for adverse possession: open, notorious, actual, continuous, and hostile, but the exclusive element is not necessary. It doesn't need to be an exclusive use. As long as you're coming on my property to do something for all those other periods of time, for the period of time and the other elements are present, it does not have to be exclusive, but then you've acquired the easement by prescription, which means you only have the right to do something. Third, there's an easement by implication. Implication, it's implied, implication, implied from prior use. What does this look like? Listen and then you can draw it out. I have a huge piece of property, I own Green Acre, and I walk across Green Acre every day for 30 years, my daily walk. For whatever reason, I divide the property into two, and I sell you half. Now I want to keep walking across my land like I've been doing all this time. Will I have the easement, the right to do that? The answer is yes. Why? Because it's implied from prior use. It's implication. Because I've been using that path for 50 years, it's implied that I'm going to get to continue to use that property for the next 50 years. Sounds crazy, John. I don't really get it. I don't either. Just know it as a definition. If I see a hypo where John has a single piece of property, subdivides it into two, and I want to keep doing whatever I was doing on the property from before, that's simply called an easement by implication, implied from prior use. That's what the hypo has to look like. Remember, we don't have to really even understand why someone would do this. You just have to know what it looks like, and you just have to know the definition. Implication, implied from prior use. Prescription, that looks like adverse possession. The writing, that'll be pretty obvious. Lastly is simply called, easement by necessity. Easement by necessity, i.e. it's necessary. I don't make up these words, it's obvious. Easement by necessity. I have to use your property because I have no other way of getting off my land unless I cut across your backyard. Easement by necessity. The classic example, the dead-end street. Now it's called a cul-de-sac, but in my day it was simply called a dead-end street. You used to live on a dead-end street, as a matter of fact. There'd be no other way to get onto the main road unless I crossed your front yard. Now I would have an easement by necessity because it's necessary for me to use your land to get off of my own land. What if the city comes along and bulldozes the dead-end street and now I don't need to do that? Then the easement by necessity would terminate because now it's not necessary. Not when you do the easement by necessity, it's not a matter of convenience. Make sure, again, in that hypo, there's literally no other way for me to get off that property unless I use your land. I will have it unless and until the necessity is no longer necessary, i.e. there are now other ways for me to get off the property. So how is it created? In writing, prescription, implication, easement by necessity. Easement can be positive or negative. I can grant you the right, give you the right to do something, or I could prevent you from doing something. Just know there are both. The big one, how long will an easement last? Forever. How long will an easement last? Forever. Once the easement is validly created, whichever way, how long will it last? Forever. Exclamation point. Put that in red ink. Unless it's terminated, like the easement by necessity when it's no longer necessary. And we'll talk about the other ways you can terminate in a second. But my point is, if in your hypo on that question, they don't give you any evidence of one of these termination things, is the easement going to continue? Yes. For how long? Forever. So hear me out on this. Don't write this down. Just listen. If I grant you an easement to come onto my property, you live in Blackacre, I live in Greenacre. We're next door neighbors. I give you the right to come onto my property to do something. Then I sell my house to Bob. Now you still want to come onto my land. Bob doesn't like you, Bob doesn't know you, Bob doesn't trust you. Must Bob let you come onto the property? Yes, because once our easement was created, is it just going to go on forever? Yes. Well, what if he didn't know about it, John? Doesn't sound fair. Shut up, who cares about fairness? That's the rule. The easement will keep on going. Generally, will he have notice of it, blah, blah, yes. But if he didn't have notice, he didn't know about it, for whatever reason wasn't in the deed, is the easement valid? Yes. So if you have 50 grantees and I have 50 grantees, and 100 years from now, your guy on your piece of land still wants to come and use that right to come onto my land, does he still have it 100 years from now? Yes. Why? Because an easement lasts forever unless it is terminated. So you have a lot of these hypos that want you to believe that because of the amount of people or time or whatever, eventually the easement will just peter out. Will it? No, because how long will it last? Forever. Unless it's terminated. What are the ways you can terminate it? Obviously by agreement. You and I can just agree, this is it. By time, we could have set it up to last only for so many months or years, and at the end of that time, then of course it is terminated. The other one would be merger. If you're you live across next door to me, and again, I've given you the right to come onto my land, but now I buy your property. If one owner buys and now owns both pieces of land, I can't have an easement on my own property. So if I merge the two pieces of property, then the easement would be terminated. Again, that hypo should look pretty obvious to you if one guy buys the other piece of land and now by merger there is no easement. And the nice one, abandonment. Abandonment. You have to both leave and express an intent not to return. You only abandon the easement if you not only stop doing whatever you're supposed to do or you're given the right to do, but you show an intent not to return. So if I have the right to go onto your land, I have a valid easement on your property, and I go to LA for 6 months, you don't see me and I'm not walking across your property every day, is that enough for an abandonment? No. The non-use is not enough. I'd have to call you and say, I just became a star on a reality show, I'm just signed a 20-year deal, I'm not coming back. Now, is there an intent not to return? The answer is yes, and then abandonment would terminate the easement. So what are they going to do? They will give you one of those elements, maybe not the other one, and you have to make sure that both of them exist. Exactly right. Covenants, separate card. Covenant looks like an easement. A covenant, again, grants the right to do something or prevents somebody from doing or restricts how you're using it. A covenant looks like a contract because a covenant is always created in writing. A covenant is a promise for a promise. It looks like a contract. Again, the easement, that can be created a bunch of different ways. One of them is a writing, but a covenant is always created in writing and looks like a contract. It is governed by contract principles. Once again, the covenant can be positive. I promise to let you do something on the property, or restrictive covenant. You can only use the land this way. You can only do something on the land in a particular way. Can be either one. The big thing, Do covenants also generally last forever once they're created? Yes. What's the term we look for that? If the covenant runs with the land. If the covenant runs with the land, does the agreement go with the property? Generally, will covenants run with the land? Yes. Generally, will it go along forever? Yes. What are the elements you're looking for if it runs with the land? You're looking for a writing, obviously, intent between the parties, notice, privity, whatever that means. We all know there's vertical and horizontal privity, but don't worry about that. If you're writing an essay, throw it down, but basically don't worry about it for MBE. And the big one, that the covenant has to touch and concern the land. Okay, that has to be the writing, intent, notice, privity, and the covenant touches and concerns the land. It's about the use of the property. If it touches and concerns the land, we intended for it to run with the land, then it will go on forever. Touch and concern the land, meaning it's not personal. It's about the use of the property. I'll give you a couple of weird, stupid examples so you'll see how obvious this would have to look on a hypo to know what to do. If I live on Greenacre, right in the middle, okay? You are my neighbor here, okay? You're my neighbor over here, and Jack Klompus lives over here. Okay, for you Seinfeld fans, you'll know what I'm talking about. Okay, I have two adjoining neighbors. I grow award-winning rose bushes on my front lawn, and I enter these rose bushes into a contest every year. This is another one of my homages to the I Love Lucy show. After they lived in New York, they went to Connecticut. I used to live in Connecticut as a kid, so I love the fact she lived in Connecticut, and this was from a basic episode, okay? What are you telling me this for, John? Because you need a little break in the middle of property, so I figured I'd throw it in there. No big deal, here we go. I live in the middle, I have two adjoining landowners. I grow award-winning rose bushes for a contest every year. I have restrictive covenants with each one of my neighbors. No one can come within 10 feet of my rose bushes. Restrictive covenant. You can't come within 10 feet of my rose bushes. Jack Klompus sells his land to the Costanzas. Jack Klompus sells his piece of property to the Costanzas. Is that covenant going to run with the land? Will that now be enforceable against the Costanzas? Yes. Because does that covenant about no one coming within 10 feet of my rose bushes, does that run with the land? Yes. And why? Because it touches and concerns the land. Is that about the use of my property? Yes. Meaning, does it matter to me who lives next door to me? No, it's not personal. I don't care who the hell lives next door. If the Brady Bunch moved in, Klompus, Costanza, whoever moves in, do I want anybody coming within 10 feet of my rose bushes? No. So as long as the covenant is about the use of the property, doesn't matter who the hell's there, it will always run with the land because it always touches and concerns the land. Touching and concerning what helps the covenant run with the land. What would be an example when it is personal, John? I'll tell you. You're my neighbor. You just come back from the Olympics. You won 5 gold medals in swimming. I want to get you something. What are you going to get somebody who just won 5 gold medals? I just built a new pool and a jacuzzi and a sauna in my backyard. So I grant you the right to come onto my land anytime you want to use my pool and jacuzzi and my sauna. I don't have to worry about insurance and lifeguards because you yourself are a 5-time gold medal Olympic swimmer. So I make a covenant with you. I promise to give you the key and the right. You can use that stuff on my property whether I'm home or not. When you sell that property to the Klompuses, Costanzas, or Brady Bunch, is that going to run with the land? No, because I only gave that to you because it's personal. That's something that you yourself will have the right to do. Do I want those other kids and those old people running around in my pool and my jacuzzi? Of course not. I only gave that because of something personal in nature to you. If I have a huge barbecue in my backyard, one of those $10,000 with the hibachi and the big grill and the whole thing, but my wife, Mrs. John, is vegan and gluten-free. You don't know what the hell's going on in my kitchen. It's crazy over there. So she's got all these little restrictions going on. So she doesn't want any of that bad stuff coming on that grill, right? If you move in next door to me and you are also gluten-free, vegan, and all those things, and my wife gives you the right to use the barbecue because it's not going to be contaminated with anything, will that run with the land? No, because when you sell to the Smiths and they want to put all the meat and the chicken and all the fat and all the other stuff on that grill, is that why my wife wanted to give it to you? No, of course not. There was something personal. She gave you the right because you're vegan and gluten-free, etc., etc. How, you mean, John? The hypo will have to look that specific, that personal. Yes, that's why I don't like to call it an exception, but when won't it touch and concern the land? When it's that personal between you and me. There's something about you and I that I made it personal for you, i.e., I don't want it to go to anybody else. I just gave it to you because of some personal characteristic or unique thing that's going on with you, and therefore it will only be a covenant with you and it will not run with the land. Also, anything with a contract. So for example, a lease. That will also be personal and will not run with the land. So if I lease you a store in a mall on one side of the mall with all kind of covenants in the lease, a year later business is really good and now you want to open another store on the other side of the mall. Will the covenants in this one go with that one? No, because it's a contract, needs to be handled separately. So any kind of those leases or individual contracts, another contract with separate covenants would have to be made. One contract will not run with the other one. Keep them separate. So if you see something very personal, then it won't touch and concern. If it's about a contractual relationship, then it won't. But 99.9% of the time, will a covenant run with the land? Yes. And therefore, will it be enforceable for 1,000 years? Yes. That's your default rule. Shut up and pick it. Next, equitable servitude. Equitable servitude. This looks like a restrictive covenant. But you're not seeking damages, you're seeking an injunction. So normally if you and I have a covenant, a promise to do something or not, it looks like a contract. So if one of us breaches that covenant, if we don't do what we're supposed to do, the other one's going to sue for damages, for money. But what if we have a restrictive covenant on the property? I don't want you to do something, and then you're trying to do it. I don't want money from you, I want you to stop doing it. I'm going to go to court and seek an injunction. Exactly. So equitable servitude looks like a restrictive covenant, but I want an injunction as opposed to damages, money. So if I see a question where it just says, I go to court seeking an injunction, ding, 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 you know you're doing an equitable servitude. The other time this servitude word is used is in this other hypo about an implied reciprocal servitude. Implied reciprocal servitude. Also, kind of sometimes once in a while you'll see the phrase equitable servitude. You're looking for the word servitude. If it's equitable, you're usually looking for the injunction, for the equitable relief. Sometimes there's a phrase called implied reciprocal servitude. This is your large tract of land that's divided up into 50 or 100 lots, and there are restrictions against all of the lot owners, like your gated community, right? Your subdivision, and everyone has the same rules. You can't paint your mailbox yellow. You can't put the car within 20 feet of the mailbox. You know, we've all been in those little communities. There's an old guy driving around in the golf cart who's in charge enforcing all these crazy restrictions. These are restrictions against whom? Everybody. As long as the restrictions are enforceable against everybody and there is notice, they will be enforceable and the restrictions will go on as long as possible. That's called an implied reciprocal servitude. You're looking for the common scheme. Common scheme means that the restrictions are common to whom? Everyone. You can't have an implied reciprocal servitude just against John. It would have to be against all of the lot owners uniformly. If there's some change to the premises, okay, some change of circumstance, the restrictions will keep on going as long as the profile, the character of the community stays the same. So if there's some sort of change in the community, there's now more people, it's busier, more traffic, will that mean that the restrictions will no longer be valid? No. For the restrictions no longer to be valid, there has to be a total change in the profile or character of the community. It started out as a residential community, but now they put shops and office buildings, etc., and now the whole community is not a small little residential, now it's a mixed-use commercial, blah, blah, you get my point. So just because it started out with 20 homes and now there are 50 homes, the restrictions will still be enforceable in that implied servitude. Don't worry about quantity. It's just that the whole character and nature, the purpose of the development has to totally change. Okay, servitude, implied, common scheme, equitable servitude, injunction, keep them separate. Next is the license. A license. If I grant you a license, you only have the right to come onto my property, the right to enter the property, but it's revocable at the will of the grantor. I grant you the right to come onto my property, but I can kick you out anytime I want. That's pretty different from the easement and covenant that we talked about, because once I give you that right, how long is it going to last? Forever. License. The way you see this tested a lot is with the ticket to the baseball game, football, the sporting event or a concert. The ticket, on the back of every ticket, it says you have the right to enter the premises, but if you do anything bad, the owner has the right to kick you out. So if you see a license, you have the right to enter the property, but it's revocable at the will of the landowner. When I moved down here to Florida, everyone knows me. I'm a passionate but an idiot Jet fan. So I used to go watch the Jet games all the time with my hat and paint my face green and my t-shirt. And by the third quarter, I was having the beer and everything thrown on me. So eventually I had to stand up for my guys and myself. As soon as I would start yelling something in support of the Jets, I would be pelted with all this stuff. And what would the police do? They would come and escort me out of the stadium. And I would argue, hey, I paid for my money the same way everybody else did. And they would say, but you only have a license to enter the property. You have the right to be here, but if you're doing something to create too much of a problem, the stadium has the right to kick you out. So the license, no, is revocable at the will of the grantor unless the interest is, unless the right is coupled with an interest. An interest. How am I going to see that? Sometimes they'll throw a future interest in there. Sometimes the answer may just say, yes, but if it was coupled with an interest, then it's not revocable. So the exception to the revocability thing is if it's coupled with some sort of an interest. Is that an exception and not generally tested? Yes. Don't worry about it, just have the definition there. So if you see an answer, when would it not be revocable at the will of the grantor? It's when the interest is, when the license is coupled with an interest. That's the exception. Just know the basic definition is it's totally revocable at the will of the grantor. A profit, totally separate from the license. The next one is a profit. A profit is just the name of the interest where I grant you the right to come onto my land to take things off of the ground. The drilling, the mining, plucking the fruit. A profit means you're coming on there not to just use the property, but to take something off of the land. They use all kind of weird words for profit, profit of this, profit of that. Just know as soon as you see the word profit, it means I'm giving you the right to come onto my land to dig stuff up, to take stuff off the land. Think of the Beverly Hillbillies. I know most of you are not old enough to remember the Beverly Hillbillies, right? But they had, the guy came on to what? After they found the oil, there were guys drilling up the oil, taking out the ore or the mine, the valuable ore from the ground, taking off stuff from the property, the fruit, etc. Profit means I'm allowing you to come on the property to take stuff off. When I see that hypo, just know to pick the answer, talking about a profit, because it's not the same thing as a license. Then we have a taking. A taking. The government can take private property for public use as long as they give just compensation. A taking. We've all heard the taking clause, hopefully. It means the government can come and take my private property as long as it's for a public use, public purpose, and they give me just compensation. Just compensation would be fair market value. Fair market value. Okay? Just know now that that public use, public purpose definition has been expanded and is much, much broader. So the government literally now can come take my house as long as they can justify it based on some greater public good. Needing for a highway, for the tax rolls, for employment, for the greater good of the community. There's got to be some public purpose. They can take my private property, but they owe me just compensation, the fair market value of what my property is worth. You'll know that when you see it. You've seen those hypos before. I just put it in here. It's another instance where if somebody, an entity, can come onto my property and literally do something to my land. The water rights. We're going to get into a couple of weird hypos now. This is horrible stuff. Just know what you can. Take the definition. Don't worry about the weird stuff. Water rights. Two types of these water questions. Generally, when you have lakes, rivers, the bodies of water. Okay? There's me and there's you. I may be a little higher on the land than you are. I'm over here, you're over here, and there's water. And it basically comes down to what can one guy do with the water that affects you? The basic definition with the water rights question is reasonable use. I can use the property reasonably. Reasonable use of the water, the lake, the pond, the river. How much can I use? Reasonable amount. I can do something that's reasonable if it affects you. You see a water rights question, you're looking for the answer, I can use it in a reasonable manner, the reasonable use, that's what you're looking for. There is another weird hypo where it's not the lake and the river, it's either the melted snow or rain. Obviously, water that's coming literally from the sky. If we're just talking about the lake, the pond, the river, the water that's currently on the ground itself, reasonable. There's another hypo potentially, what if the water is coming from the sky as the snow is coming down or the rain is coming down? What can I do with that water that may affect you? Basically, if you see that kind of an hypo, the owner can use whatever reasonable means is necessary to alter the flow of the rain or the snow. Reasonable means to alter the flow, even if it could harm you to some degree. I can alter the flow. One owner can alter the flow if I do it in a reasonable manner, even if it may harm you a little bit. One owner can do that in a reasonable way, even if it may harm you a little bit. Okay? I'm up here, you're down there, there's water, reasonable use. I can't flood you out, I can't make you so thirsty you don't have any access to any water. How do I use the water up here? In a reasonable way so you can have some of it. If you see the rain or the snow, once again, I can do whatever is necessary in a reasonable way to alter the flow, even if it harms you a little bit. Done? Done. Think of reasonable water and you'll be okay. Crops. There's the crops question. The fructus this, the fructus that, the crop question. There's two kind of crops, but the bottom line is it's going to be the same answer. If the crops are on the property, they're considered part of the land, we're talking the trees, the grass, something that's on the land naturally. Any kind of thing that's on the land naturally is considered part of the real property and will go with the land when you sell the property. So if I'm going to sell you Greenacre, anything that's naturally part of the ground is considered part of the real property and goes along with the title to the property. If I'm planting something, I'm planting corn, I'm planting something man-made, I am planting something in the ground, it's still going to go with you, but it's called personal property. Personal property versus real property. Is the bottom line is that it's still going to go to the person I'm selling the property to? Yes. All you need to know is the definition. If it's part of the ground naturally, it's considered real property. If I planted it into the ground, it's just called personal property. Keep the two separate. You can get another question right as long as you know which one they're referring to. But ultimately, if I sell you Greenacre, is it going to you, the grantee? Yes. There's an exception. When would the crops grown by me, if I'm planting something in the ground, when will it not go with the property? When either it's expressly held by the grantor, it's expressly we agreed that I'm keeping it, or in a tenancy, except for a tenancy for years. In a tenancy, if I have the right to harvest the crops that I planted before the end of the lease term. If I'm a tenant, not a tenancy for years, and I had the right to harvest it before the tenancy ended, then I have the right to keep it for myself. If we expressly agreed that I was going to keep it, then I would also be able to keep it. But otherwise, will it go with you? Yes, it will. And all I need to know is if it's naturally part of the ground, it goes to you as real. If I planted it, it goes to you as personal, but inevitably it goes along with you. It's just a definition. Don't worry about it. The weirder the hypo looks, the more you revert to a simple definition. These support rights, these are also crazy. I'll just give you the basic rule to see, and you do the best you can. I'm on Greenacre, you're on Blackacre, two adjoining pieces of property, okay? I'm doing something on my property, I'm excavating. I'm blowing stuff up on my land and it damages your property. I'm over here and I'm blowing stuff up. I'm digging up my own land, blowing stuff up. And over there, it damages your property. The key you're looking for is if your land, the adjoining land, is developed or undeveloped. If you have an undeveloped, a blank piece of property, and I'm doing something on my land that causes you damage to an undeveloped piece of property, I am strictly liable. Strict liability is the answer you're looking for. If it's a developed piece of property, you have a building, you have something on your land, I will be strictly liable if there would have been damage no matter what, if it would have happened anyway. How will you know if it would have happened anyway? They will give it to you in the answer choice. So again, I'm doing something on my land, you have an undeveloped piece of property, I'm doing something, And what happens? I was blowing stuff up. It damaged your land. Strict liability. You have a building on your land, and it would have happened anyway. Strictly liable. If it wouldn't have happened anyway, then I'm liable for negligence. Negligence. So when do I pick strict liability? When you have an undeveloped piece of land, it's always strict liability. If you have a building and it tells you that it would have happened no matter what, that's strict liability. But otherwise, when you have buildings or development on your property, I will only be liable for negligence. Just keep it for a definition and study what the hypo looks like, developed versus undeveloped piece of property. If I let somebody come on my land and dig, mine, if I'm allowing people to come, this is called the so-called subjacent. Things are going on underneath the ground on my land. They're digging up my ground. And because they're digging it up, it affects you. It affects you. Basically, I'm going to be liable based on negligence. If you see that they're digging stuff up from the ground, I gave them the right to do that, you're looking for the negligence answer. Keep it simple, otherwise you'll get into way too much minutia, and quite frankly, it's not worth it. Okay? Adjoining pieces of property, it's undeveloped, strict liability. There's a building on it, your land is developed, I'll be strictly liable if it would have happened anyway. If they don't tell me that, it's just negligence. If I'm allowing someone to come on my land and dig stuff up, they're doing something underneath my ground, I'm basically going to be liable for negligence. Crazy couple of hypos. Water, reasonable. The crop business, if I'm planting stuff in there, it's just called personal property instead of real property, but it's going with the property anyway. And this weird lateral rights subjacent thing, it's just a definition. Make your card. You'll see it once in a while. Study the hypo. Don't run to the answer choice. Next is nuisance. Nuisance. The nuisance. There's a private nuisance and a public nuisance. Private nuisance, the unreasonable interference with the use and enjoyment of your property. Use and enjoyment of your property. The key here is that the interference has to be unreasonable by an objective standard, to a reasonable person. Whatever I'm doing, I'm cooking, the noise, the light, the smell, whatever's going on my property, unreasonably interferes with your use and enjoyment. Done? But the interference has to be unreasonable to you, and who are you? A reasonable person. So if you have the weird allergy, the abnormal sensitivity, then it's not going to be a nuisance. So if I'm playing basketball in my driveway at 5 o'clock in the afternoon, and you're the Costanzas or Jack Klompus, elderly people who want to go to sleep after the early bird, they want to go to sleep at 5 o'clock in the afternoon, the banging of the basketball on my driveway would be keeping you up. You're going to claim I'm committing a nuisance because I'm unreasonably interfering with the use and enjoyment of your property. But is playing basketball on a driveway at 5 in the afternoon unreasonable to a normal person, to a reasonable person? No. Therefore, it would not be a private nuisance. If I'm playing Def Leppard music with extra bass and treble, that's a late 80s heavy metal band for you young kids out there. If I'm playing heavy metal music at 3 o'clock in the morning with heavy bass and treble, and you can't sleep, would that be a private nuisance? Yes, because that would interfere with any reasonable person's use of the property. Always be looking for, is it interference unreasonable to an objective person, abnormal sensitivity, allergy, some sort of thing that only affects you, then it will not be a nuisance. Public nuisance. Public nuisance. Generally, this is something that affects the public at large. Public nuisance. Usually, who brings a public nuisance claim? A government official, right? The local attorney general. District attorney, some public official brings a public nuisance claim because who's it affecting? Everybody. The trick here is if a private individual, if John brings a public nuisance claim, I have to prove special damages, some sort of unique harm. Don't worry about how much it is or what it is. Just know it's public or unique, a public nuisance claim brought by a private individual, John, not a public official, has to prove special, unique damages. It's just a definition. Know what you're looking for. Lastly, in this section, we're going to talk about something called common interest owned community. Common interest owned community. You'll know the examples when I give them to you. We've talked about owning title in a house, myself, me giving you the right to come on to my property. Now we're going to talk about common interest owned community. Okay, let's get the definition. We'll go through some basic examples. A common interest owned community is a development where the individual owned lots, the individual owners, have a covenant requiring the payment of dues to an association. The payment of dues to an association. This is called common interest owned community. We're all in it together. What's going on here? It's a development where the individual owners have a covenant requiring the payment of dues to an association. What's the association? The association provides services, facilities of the common areas, the common property, and they enforce the covenants on the property. The association, the homeowners association, they make sure that everyone's following the rules and they provide services to the common areas. It's a common interest owned community because what do we each as owners have to do? Pay dues to the overall association. Okay? That's how you know you're doing something about common interest owned community. The payment of dues is required. There are different types of common interest owned communities. One is simply called the Property Owners Association. Property Owners Association, where the owners are required to belong to an association and pay the dues. Just called that. Property Owners Association, where the owners are required to belong to the association and pay the dues. The common one you're all going to know now, separate card, separate rule, is the condominium, the condo. Condominium. Separate little definition. Condominium, the laws for condo law is created by statute, and you file a declaration. Declaration is a fancy word for a piece of paper. A declaration is going to set out, I'll talk about it in a minute, but there's a piece of paper called a declaration. So when you create a condominium created by statute, there's a declaration, also called a master deed, just a fancy name for it, a declaration, master deed, and a plat, P-L-A-T, a plat. The plat is simply describing the physical boundaries of the units as well as all of the common areas. So if you see the term plat, that's just a description of the property and the common area. The declaration for the condo is the piece of paper setting forth all the rules by which the condo will be governed. Simple. The declaration. Again, as I just said, it sets forth some obligations and rights of the owners and also declares each owner's share, each owner's individual share of the condominium so they can allocate the expenses. How much taxes are you going to pay? Maintenance. So the declaration sets forth all the obligations of the owners and the shares of the percentage of share for each owner so we know how much it's going to cost for maintenance and taxes and insurance, etc. Declaration. I don't like to mix terms, I'm all about separating it, but think of declaration, it's almost like the constitution of the development. It's like the rules by which we're going to live by is the declaration, just a piece of paper. Each individual condominium unit, each owner, if I own a condo, I own the interior structure of the condominium, the walls, the ceiling, the individual structure. And I, as the owner, will pay taxes, insurance, and I can get a mortgage on the condo, right? A lot of people bought a condo. You automatically own the inside structure, the physical being, the walls, ceiling, etc. of the unit. Your obligation to pay taxes, you're going to pay insurance, you'll pay maintenance for your unit, and you can mortgage your individual unit. But then we also have the common areas, the lobby, the pool, the workout, the gym, the walkways, the gardens, all the common areas in the condo building or the set of buildings. Each owner owns the common areas as tenants in common with the other respective owners. So if I live in unit 12, apartment number 12, I own all the common areas with all of the other neighbors, all of the other tenants from 1 to 11 and 13 to whatever, as tenants in common in the common areas. I may not partition those common areas. Everyone's in it together. There's no partition of those common area ownership. You can't separate ownership of the individual unit from the common area. It goes together. I do own the individual unit, the structure by myself, but I own all the common areas as tenants in common with my neighbors. There is no partition and I can't separate that ownership. One goes with the other one. I pay a fee to the association, pay a fee to the association for the cost of the maintenance of those common areas, to have the guy come and cut the grass, to clean everything up, keep the pool nice and clean, allegedly. Paying a portion of the taxes for the common areas. I pay a portion of my taxes for the common areas as well. So we have the property owner association, then we have the condo, now we have the co-op. You've heard the term may be called a co-op. If I'm going to get an interest in a co-op. This is separate. Keep this separate. Another example of the common interest-owned community. A co-op is basically a corporation that owns one or a series of buildings. The co-op is a corporation that owns one or more buildings, and they lease the individual units to shareholders. If you're going to get a co-op, an apartment in a co-op, you're dealing with a corporation. The resident or the tenant owns shares of the corporation. I literally own shares of the entire corporation. And also the difference is there's a mortgage on the whole property, a blanket mortgage they call it, a mortgage on the entire property, not individual mortgages like I have on my little individual apartment. That would be for the condo. If it's a co-op, the mortgage is on the entire piece of property. So each tenant is going to pay a fee for their share of the mortgage, the taxes, and the maintenance. I.e., if a tenant fails to pay their share, technically could the whole mortgage on the entire piece of property be in default? Yes. So think about that. If you live in a condo, if you have apartment 11, I have apartment 12, apartment 13, we only own the structure, and we can take out a mortgage for our individual apartment. If I don't pay my mortgage, is that going to affect the whole building? No, it'll just affect my individual unit. If I'm in a co-op, there's a mortgage on the entire building. I'm basically paying a share of the whole mortgage fee. So if I don't pay it, that's going to affect the entire mortgage. That's how definitionally you can see a question testing you on the difference between a condo vis-a-vis the co-op. Running a common interest-owned community. Okay, just some basic terms on how this is all going to be handled. Condominium and a co-op. Again, we have the declaration, the piece of paper that's going to govern what are the rules. Think of it again as that single piece of paper that's going to govern the rules, the covenants, the easements, what is going to happen among all of the owners. There are other pieces of paper, bylaws, articles of incorporation, that also will govern the association. All of these pieces of paper together collectively are called governing documents. I just give you that so if you see a phrase governing documents, that means the declaration and all the other related pieces of paper that will help determine how the whole community is run. The declaration is always given the most weight. The declaration is always given the most weight. So be looking for that's the one that's the most important. It sets out the original rules, obligations, and covenants for the property. The association. The property association manages the property, the day-to-day operations of the property, and enforces the rules. So we have the declaration, which sets forth the rules. The association. All heard that term, or maybe you've been involved in one. Just the association will manage the day-to-day. There's a board. The association is run by the board of directors, the board. These are usually those very tough people who are in charge of then enforcing all of the actual rules themselves. So you have the association basically made up of all of the tenants. You have the board, which runs everything for the association. They're elected by members of the association, and sometimes they hire a property manager. Sometimes they hire an individual to kind of be the CEO to run the whole thing. Association made up of the residents. The board is the group sitting around the table that then meets to help enforce and do everything on a day-to-day basis, and they can hire a single manager to do that. We also have the developer, the guy that actually developed the property. He creates the association to manage the property, make sure everything is going well. Over time, the developer is going to transfer the power to the association. So the developer obviously creates the whole thing. Then over time says, look, now I'm done building the property. Now I'm going to hand over power to the association. Now the association takes control of the property. Can the association terminate their contracts with the developer and take everything over 100%? Yes. Developer starts, basically eventually hands over. Then can the association terminate their rights with the developer? Yes. And generally, the association has 2 years to vote, 2 years to vote to terminate their relationship or any contracts with the developer. And it must be by a 2/3 vote. 2/3 vote, and they have 2 years to vote to terminate any contracts or agreements with the developer, so now they can do everything by themselves. The developer may not use their power. Developer may not use their power to change that declaration in any way that would change the character of the development, unless the declaration allows them to. So we're going to remember, the declaration is that piece of paper that sets forth everything, all the rules and obligations. The developer cannot use their power, while they still have it, to change the declaration, to change the character or nature of the development, because obviously whatever I created, I'm supposed to be able eventually to hand over to you, the association. I, as a developer, can't do anything while I have the power to change it unless the declaration happened to give it to me in the first place. And I'll know if they did because they will tell me. Then we have the powers of the community. So now how is it run? We have the declaration, we have the association, the board acts on behalf of the association to do the day-to-day. The board can have a manager, an overseer, if you will. We had a developer who started the whole thing. Now we simply have some of the powers that the community, through the board, gets to do. The board has powers reasonably necessary to manage the property. The term you're looking for is the board acting reasonably necessary for the property at large? What are they going to do if it's reasonably necessary? Levy assessments and fees. If assessment, we have to do a new roof, we have to build a new pool, we have violations, code violations, we have to fix them, they will levy an assessment. An assessment is basically like a tax on all of the members to kick in some money so we can fix or improve the property. Fees, if you're late with your maintenance, late with this, late with that, any kind of fees, any kind of penalties, any kind of assessments. They can manage and improve the common areas. We need new tiling, we need a new gym, we need a new equipment. The board, through the community, on behalf of the community, can do those things as long as they are reasonably necessary. Any of these rules that they're going to create for the betterment of the whole property. Any rules that the board wants to create has to be reasonably related to furthering the legitimate purpose of the association. So any rules that the board wants to create, again the buzzwords, reasonably related to furthering the legitimate purpose of the association. Basically doing everything for all the residents' benefit. If they're going to make rules, they have to be reasonably related to furthering the legitimate purpose of the association. They can't make rules which would restrict the use or occupancy of any individual owner. They can't do anything that would restrict the use or occupancy, i.e. they can't discriminate against any individual owner. Remember, they're supposed to be looking out for the greater good, the community at large. They can impose fines, reasonable inspections of the property if they think you as an individual tenant are doing something wrong, violating a rule. Can they have reasonable inspections? Yes. Can they impose fines if you're doing something? Yes. Can they take away your privileges to the common areas if you're violating a rule? Yes. They also can litigate in their own name as the association. Can the association, as an entity, sue? Yes, it can. The duties to the members. The duties to the members of the community. The members have to be treated fairly. The standard is ordinary care. Ordinary care in managing the property and the financial affairs. The board, in a duty to the members, have to act fair, ordinary care, both for managing the property itself and for the financial affairs of the entity. They have to give reasonable access to the members for information, the day-to-day, the financial matters, reasonable access of information, transparency to the members so they know what the heck is going on. If a member makes an accusation, the burden is on the member to prove breach by the association. So again, if I don't think they're doing something correctly, can I bring an action? Yes, but again, the burden's on me to prove there was a breach by the association. The duties of the board itself, the duties of the board, to act in good faith, and the standard of care is an ordinary director of a common interest-owned community. We always talk about duties, right? I have a duty, reasonably prudent person, but if I'm doing something particular or professional, I have the duty to act like other similar professionals. So the board, working on behalf of the association, has a duty to act in good faith and as an ordinary director of a common interest-owned community. The board has a duty to act like other directors of common interest-owned communities. Standard of care. So if they didn't do something, if they were negligent, the standard I would be having to prove is they breached the standard of another director of a common interest-owned community. And the members of the board are not jointly and severally liable. They're only liable for their percentage share of fault if something happens incorrectly. No joint and several liability. The members of the board would only be responsible for their own percentage of fault. So again, that's a lot of little rules. Just think big picture, big picture. Declaration is simply the piece of paper sets forth all the obligations. All the residents basically make up the association. There's a board that represents the association. They can hire a single manager, but the board basically just makes sure that everything's okay across the property. They can levy assessments and fines that we each have to kick in. They can make improvements. They have to be transparent. They basically have to do everything for the betterment of everybody. Give us reasonable inspection, reasonable access to information. They can inspect if they think something's going wrong. Duty to act is ordinary care. Condominium, I own the individual structure, but I can mortgage my own interest, my own building, my own apartment, my own unit. And I own the common areas of the condo as tenants in common with the other members. A co-op is a corporation, and I only own shares, and my fee, my share that I'm paying, the money that I'm paying, covers the whole mortgage. The mortgage covers the entire building. So if one of those tenants screws up, that could potentially be a problem for the entire mortgage. Keep the co-op rules, share corporation, separate from the condo, the individual unit owner. Condo association, the basic definitions of the board members, no problem. They can levy assessments and fines, etc. They have a duty for access. Keep everything separate. Rights in land, easements, covenants. Once they're created, they last how long? Forever. Keep the easements separate from the covenant. Covenant, you're thinking touching and concerning the land. Always has to be in writing. Easement, you're thinking can be created a couple different ways. License, that's the one where it's totally revocable because I'm just letting you come on the property. The profit, I'm letting you come do stuff, take stuff from my ground. No big deal. I keep the water right thing, reasonable use. The stuff on the ground, if it's the trees and the grass that's natural, it goes as real property. I plant stuff, it goes as personal property. Every one of these things, you're just thinking definition. What does this look like? What does this look like on a hypo? It's a lot of material. Make sure your outline is nice and organized and neat and you keep everything separate. But I promise you, if you just get comfortable with some of these things, with some of the basic definitions, then you get comfortable with what some of this looks like on a question, you will knock this out of the park. Why? This is where your practice of the questions comes in. Put the pencil down and just listen. I'm about to be finished. So take a deep breath. We're done with the law. Just want you to hear me out on this. Some of these kind of questions you just have to do, and even if you get them wrong, the focus is just see what it looks like. Some people can't even tell the difference between these rules. You have to do a few of these to focus on the facts, see what it looks like, and say, aha, this is what he was talking about. So this is what that easement by implication looks like. So that's what the necessity thing looks like. So this is the thing where the Abel and Baker created an easement. Then there were like 7 different grantees. The easement still lasts forever, so that's what this looks like. Even if you get a couple of wrong, print out, highlight the hypo, whatever you need to do and say, so now even though I knew the law and I had it on my card, I just needed to see what it looked like. That's the difference between learning from your practice questions versus just doing hundreds and hundreds of questions. If you're going to do a condo question or a co-op question, there will probably always be one answer talking about shares of a corporation or a mortgage on the whole property versus the mortgage to the individual unit. They're betting on the fact that you don't know the difference between the two definitions. Some people don't. I yell at them, stop doing the questions and put the law in your head. Some people know all of the law, but don't read the questions carefully because they're going too fast. Slow down, make sure you see what it looks like in the facts, and you go when you see the answer that you know is the answer you are looking for. What are you supposed to do? Shut up and pick it. Go kill rights and land.